Please be seated. Veuillez vous asseoir.
Thank you and welcome back. We will now go to question from the bench. Judge Ibanez has a question. Judge.
Thank you, Mr. President. The question was for the League of Arab States, but now as they are not here, I'm going to do the question in an open manner so anybody can answer the question. The League of Arab States has indicated that its entity has and continues to be a supporter of the court. Given Jordan's refusal to arrest and surrender Mr. al-Bashir to the court, I would like to ask in what way the League envisages cooperation with the court in the Darfur situation. It is a very pragmatic question, and I would like pragmatic answers. Thank you.
We thought that the ambassador would be away only from tomorrow, but apparently, all right. Is anybody able to assist with that? If not, we can then. Yes, yes.
Thank you, Your Honor. Actually, pragmatically, if we're speaking in the context of international organizations, because we had similar situations like Jordan had with President Bashir's visit.
So we can make clear on the record that you're not speaking for the League of Arab States. No. You are the Legal Council for the African Union.
I know my country is a member of it, but no.
But please proceed.
Thank you very much. In fact, one of the reasons we have Article 98 in the Rome Statute is to protect this kind of situation. So if we're talking about the cooperation within the parameters of the international organizations like ours with states parties, then it should be away from our context, because there are agreements. If I recall correctly as well, your question, Your Honor, with regard to the policy issue with international organizations. It's not only a policy that we grant immunities, but also it is a matter of law, because we have legal obligations imposed on all states parties to our conventions, our member states, and those who host even any of our meetings. So this is a legal obligation. So the cooperation envisaged with the ICC, it should be within the parameters of the international legal system. It should not go beyond it. This is how we see it.
The interesting, the interesting, should I say, knob there that we need to get around is the value of Article 103 of the UN Charter in there. And that's what probably triggers the question whether to look at the matter from the perspective of policy or of law. We've had submissions in the room in the past few days that in light of Article 103 of the UN Charter, when that article sponsored, so to speak, a UN resolution taken under Chapter 7, the sponsors it into the equation, then that will cancel out any regional agreements that grant immunity. That argument has made in many ways. And then that raises the question, all right, assuming that to be the correct way to look at it, so 103 clears out the way for Chapter 7 resolution. That's how come the question of policy comes into it. So, right, so regardless of that, yes, we may agree to that effect of 103. Does it also assist to make the system work? To say, okay, ICC, when there's a regional organization dealing with regional issues, it may be best to not go there and scare the cow, so to speak, in the manner of speaking. Like dumping something in there that frightens everybody who wants to solve a sensitive problem. That's the point.
Thank you very much, Your Honor. Well, Article 103 does not actually speaks of removing the agreements. Yes, it addresses the bilateral agreements and the regional agreements, but our agreements are not in conformity with the UN Charter. We still have within the UN Charter and the host country agreements, even signed by the United Nations itself, to host events anywhere, it includes the immunities. So we are working still within the parameters of international law. And our decisions, whether when it comes to the policy issue or when it comes to the legal issues here, it is still in conformity with international law and with the UN Charter. Thank you so much.
Thank you.
Can my colleague add something?
Yes, quickly, and then we'll go to Mr. Mali Faraz.
Thank you very much, Your Honor, and I will be brief. I will just point out that the proposition that you put forward assumes, in fact, that there is a legal obligation under the Charter. But in this instance, there isn't a legal obligation under the Charter. I think counsel for Jordan make that absolutely clear. The only legal obligation under the Charter, which would then take on an Article 103 character, is an obligation on Sudan, not on Jordan, not on South Africa, not on any other state. So there is no competing legal obligation under the UN Charter. That's just the point I wanted to make.
But he did not assume anything. I said, just for purposes of argument, assuming that to be the case. That's the premise. It wasn't. Yes. Thanks. Please.
Thank you, Mr. President. I will attempt to answer the judge's question on the basis of teaching the law of the League of Arab States for almost 15 years now. To the best of my knowledge, the League of Arab States has consistently avoided dealing with questions of alleged violations of human rights and humanitarian law in its member states. The first time the League of Arab States did invoke competence to deal with such a matter was in the popular uprising against the regime of the late Colonel Gaddafi. In that instance, the Council of the League of Arab States, without invoking a specific legal basis, decided to suspend the participation of Libya in the activities of its organization. In reality, it didn't suspend the participation of the state of Libya. It did suspend the participation of Colonel Gaddafi's regime. The second time that the League of Arab States got involved into a similar situation was in the case of Syria. And following the example set by suspending Libya, it also suspended Syria from the activities of the League of Arab States. Thank you.
Thank you very much. Any more reaction? Yes, please, Mr. Wood.
Mr. President, to be clear, I'm not speaking for the League of Arab States either, and I'm not going to go into policy and the history of the Arab League as the previous speaker has sought to do. I just wanted to reinforce the point that Professor Taladi has made on behalf of the African Union, because reference was made to Article 103 of the Charter. Article 103 is a crucial provision of the Charter. It's the article that gives power to the United Nations, and in particular to the Security Council, to override other international obligations. And it's very short and very clear. It says, in the event of a conflict between the obligations, I stress that, the obligations of the members of the United Nations under the present Charter and their obligations under any other international agreement, which may, if necessary, include customary international law, their obligations under the present Charter shall prevail. And so it's only if an obligation had been imposed upon members of the Arab League to not to apply the obligations under their agreements on immunities that this would come into play. And it's been our contention throughout that no such obligation was imposed by Resolution 1593. Since this point is in a way related to your question about paragraph 31 of the celebrated Tadic appeal, would it be a moment to talk about that? The sentence to which you drew our attention says that these powers, that is, powers of the Security Council, are coercive vis-à-vis the culprit state or entity, but they are also mandatory vis-à-vis the other member states who are under an obligation to cooperate with the organization and with one another in the implementation of the action or measures decided by the Security Council. This is a sentence that occurs in a paragraph which is a brief general statement by the ICTY Appeals Chamber concerning the range of measures envisaged under Chapter 7. As far as I can see, this distinction between powers that are coercive vis-à-vis what the Chamber referred to as the culprit state, but also mandatory vis-à-vis other member states, wasn't actually picked up later in the decisions, so we can't get much guidance from that. But it seems to me pretty clear what the Appeals Chamber was saying. The Appeals Chamber was drawing attention to the various effects of binding decisions of the Security Council. They are, if you like, coercive vis-à-vis the state against which the measures are taken. For example, when the Council authorizes the use of force against a state, or if it imposes sanctions upon a state. And they are mandatory on all the member states to whom they are addressed, which is usually all member states, mandatory in the sense that they are all legally obliged to impose the sanctions. And as Professor O'Keefe said this morning, that sentence from Tadic says nothing about whether or not the provision of a Security Council resolution is legally binding on its addressees and would therefore prevail, if it was, over the other obligations by virtue of Article 103 of the Charter. It says nothing, the statement from the Appeals Chamber of the Yugoslav Tribunal is saying nothing about when provisions in Security Council resolutions are legally binding. It's talking about the effects of legally binding provisions and saying what kinds of effects they can have. And in our case, it's quite clear that under Article 25 of the Charter, it's only decisions of the Council that can impose obligations on member states. In our case, the word urges is, to my mind, completely clear. It is not binding. The use of the non-binding urges reflected a clear policy decision of the Council, and I think it's not difficult for any of us to imagine why non-parties to the Rome Statute, including certain permanent members of the Council, would not have accepted the imposition of a legal obligation to cooperate fully with the court. It's pretty clear to me that the resolution would simply not have been adopted if it had imposed an obligation on non-parties. Thank you, Mr. President.
Thank you very much, Sir Michael. I will come back to you later. I will come back to you later on something after my colleagues have had a chance to also ask. And I will be asking you about the Kosovo advisory opinion in the context of the UNMIC regulation. You know that case very well, and that was adopted pursuant to Security Council Resolution, I believe, 1244. But I'm just letting you know that So I will now invite my. Oh, somebody wants to.
Yes.
Yes, please.
Your Honour, I just want to make a brief point because of Mr. Woods' last intervention concerning the Tadich Appeals Chamber and the paragraph 31 that Your Honour pointed to. He's right that paragraph 31 says that the powers are coercive in relation to, as they put it, the culprit state, and they are mandatory vis-a-vis other member states. He made the further submission that it can only be a decision of the Security Council which then binds the other state. In this regard, Your Honours, the decision in Blaskich, the trial chamber subpoena decision, is important. That decision stands for the proposition that the tribunal there could issue binding orders to states and that states have a duty to comply with those orders. Throughout Blaskich, we see reference specifically paragraph 81, 82, further paragraphs 86 and 132, this point that the establishment of the ICTY, now we're back in the ad hocs, by the Security Council under Chapter 7, quote, clearly calls for the priority of measures adopted by the Security Council to maintain or restore international peace and security, and subordinates state sovereignty to these concerns.
Can we look at that in the context of what that decision was talking about? It wasn't about Croatia? Requiring Croatia to produce documents? Was that the one?
It was specifically directed to Croatia, but it was applicable. Its comments to states in general. For example, Your Honours, if you go to paragraph 86, it is, the court says it is clear that states are obliged to comply with requests for assistance from the ICTY. And that's the way the decision was always read. All countries around the world read the decision in that way, that they were obliged, confirmed by the Blaskich Appeals judgment. Now, the distinction in that case was between what is compulsory, what is mandated upon member states, because all the comments are made in relation to member states, versus coercive powers. And Blaskich, in both the trial chamber level and the appeals chamber, made the distinction between mandating member states but reserving coercive powers to the Security Council, so for sanctioning. And it works in the same way here. I don't recall offhand the specific provision of the ICTY, but it was similar to 87.7 here. So that's the coercive sanctioning mechanism. Refer back to the Security Council. But nonetheless, it was still clear that the mandate, the compulsion, was upon all member states. Thank you.
Thank you very much. Yes. Mr. Wood, let me speak. Yes, please, Ms. Roki, if you...
Mr. President, with great respect, what has just been said is utterly beside the point. From where did the International Criminal Tribunal for the former Yugoslavia draw its mandatory powers? Now, let's leave aside this coercive business. And I've dropped my glasses, without which I'm relatively blind. I've found them again now. In paragraph 4 of Security Council Resolution 827 of 1993, acting under Chapter 7 of the Charter, the Security Council decided that all states were to cooperate with the International Criminal Tribunal for the former Yugoslavia. That was then translated into its statute, Article 29. The power of the ICTY to bind states in cooperating with it, providing assistance or whatever you want to call it, and leaving aside this complete smokescreen of coercion, the power to bind them came from the decision of the Security Council, adopted under Chapter 7, but to this extent irrelevant, in paragraph 4 of Security Council Resolution 827. That is the beginning, the middle, and the end. Okay, so that is the essential phenomenon here. It is not that the word urges or any other thing like a recommendation can create a binding obligation, only a decision.
Thank you very much. I'll return now to Jordan.
Well, thank you very much, Mr. President. And just to say that I agree fully with Professor O'Keefe. I couldn't have expressed it as well and as forcefully as he did, but I do agree with that. And it reminds me that there was another suggestion about this word urges, which came up, I think, this morning. And it was that the Council urging states to cooperate was sufficient to absolve them from complying with their obligations under international law, including their obligations in the field of immunities. But I think it's very clear, Mr. President, that complying with a non-binding call from the Security Council cannot be a circumstance precluding wrongfulness under the law of state responsibility. Those circumstances are set out exhaustively in Articles 20 to 25 of the 2001 Articles. And if there were to be such an interpretation of a non-binding call of the Council, it could have very dangerous implications. The Council is often encouraging states to do things, calling upon them to do things. If that were to override their obligations, for example, their obligations on the non-use of force, that could have remarkable and remarkably dangerous consequences. So, with respect, I think that interpretation of a non-binding call of the Council is simply not correct as a matter of law. Thank you, Mr. President.
Yes, please, Mr. Jallow.
Thank you, Your Honors. I was hesitating, but I thought this might be a moment to make a couple of observations. And Your Honors, these observations actually relate directly to the question about tardage. And Mr. Wood and Mr. O'Keefe, I think, have made an excellent point, because the key issue is not so much about what they decide versus urge. What context is taking place is equally important. And he, Mr. O'Keefe, that is, mentioned Resolution 827 of the Security Council, and paragraph 4, where the Council decides. It decided, and this was in the context, as Your Honors well know, of the establishment of the ICTY. What I find very interesting, and this is my part of that first observation, when you go down as the tribunal was now carrying on its work, you will find subsequent resolutions of the Security Council where, for example, in Resolution 1166 from 13th May of 1998, the Council passes a decision whereby it is reminding states of their duties to cooperate with the tribunal. Why is that important? Of course, it's important because earlier we were having the suggestion that the implication of a bindingness, if you will, is derived from precisely the fact that you're using Chapter 7. So in this context, in paragraph 3, the Security Council says it urges all states to cooperate fully with the International Tribunal and its organs in accordance with their obligations under Resolution 827 from 1993, referring back. Now, I will spare you the rest of them, but there are several other resolutions, Your Honors, that are directly relevant to the question of where do you get this duty, this obligation to arrest. And so, for example, in a subsequent Resolution 1207 from November 1998, the Council does the same thing, where now it reiterates its decision. In Resolution 1503 from August of 2003, it calls on all states to cooperate, including in this context with the International Criminal Police Organization. And then finally, in terms of these examples, it reaffirms in Resolution 1534 from 2003 the necessity of trial of persons indicted by the ICTR, and reiterates its call on all states, and specifically even lists a number of individuals that are very familiar to anyone who's worked in the field of international criminal law, Radovan Karadzic, Ratko Mladic. So, Your Honors, my point is, in terms of takeaway, is that we shouldn't make too much of, when they use urge, are they really indirectly saying something that is binding on them, when in the context of this particular case, the language of urging is not that helpful, because the whole context, the obligation is really just on Sudan. And my second point, Your Honors, is actually provoked by a comment made earlier by Professor Newton, and I thought I might introduce it here, because again, it's dealing with this element of cooperation.
I think we're to keep in mind here, though, that the urge part of the resolution 1593, quite apart from the question from your submission just now, whether calls upon means something different from urges, we can debate that for another 2 weeks. I'm not sure. Quite apart from that, in the context of 1593, the language of urging, it's not for Jordan. If I'm correct, please point out. I think there is a certain obligation on Jordan for purposes of 1593. The urging upon part deals with states parties who are not parties to the Rome Statute. They're then urged to fully cooperate. That is the orientation of that concern. Again, you can correct me if I'm wrong.
Your Honors, if I... Huh? Yeah, probably, yeah. Your Honors, if I may, just very briefly on that point. So I have here 1593, and it does have the sequence that we're used to in terms of the Security Council when it's taking a decision. So you have the preambular statements that are doing things like taking note, recalling, and of course determining, acting, and then deciding to refer. And this is of course paragraph 1. We talked a lot about this morning. And then in paragraph 2, directly deciding that only the government of Sudan and all other parties to the conflict in Darfur shall cooperate fully, and so on. And I would like to come back to that much later on. And essentially, within that same context, then using this at the end of that sentence, Your Honors, urges all states and concerned regional and other international organizations to cooperate fully. And it's very interesting for me that those that have been urged later on will include even the African Union in terms of its own role within the context. So I think we shouldn't, if you will, make urge now deciding within a context where it's very clear that it's saying, we know, and I think Mr. Wood was correct, that there are members of the council that were very hesitant, even back at Rome, at this idea that the court might even have jurisdiction over the nationals of state parties. I'm sure, Your Honors, you don't need to be reminded of this, but I just want to lay down the marker, because even very recently we're seeing even a great power, just as recently as a few days ago, reiterating this as its first major issue with the ICC. So if it's permissible to the court, Your Honors, I had said I have 2 points, and this was the first point. And the second point, I can be very brief on this, and this was in relation to Mr. Newton's comment that members of the Security Council, despite repeated pleas from the office of the prosecutor, and Madam Prosecutor, of course, in a very difficult position, have not reacted. We would just add that on one occasion, when the matter was addressed, this is the matter raised by Mr. Newton, it was made quite clear that to establish an effective duty to cooperate, what was required was for the council to establish a duty under the resolution to cooperate. And I would like to quote, if you will bear with me for a moment, Your Honors, an excerpt of the statement of the Republic of South Africa. South Africa, in December of 2012. And the delegate to the 6th committee said, who was of course in the Security Council at the time, said as follows: over the past few months, there have been several meetings, official and unofficial, in which the relationship between the Council and the ICC has been examined. The constant and consistent refrain in all of those meetings has been that the court is caught in the crossfire of the political dynamics of the Security Council. That is reflected in the skewed manner in which the referral resolutions themselves are drafted. And it's very interesting given the value that we're attaching to them here. And that's just my own comment. And I continue with the quote. With respect to cooperation, and this is going directly to the issue, with respect to cooperation, for example, some members of the council, those that have the greatest influence on the referral resolutions, have reserved for themselves the right to cooperate with the court, which raises serious questions about the credibility of the process. about the credibility of the process. In order to enable the ICC to execute its mandate, the Council should insist on full cooperation with the Court by all state members of the United Nations. All state members of the United Nations, including permanent members of the Council, and this, of course, is difficulty, in situations that it refers to the Court. Until that question and other related questions are resolved, securing cooperation may continue to be an uphill battle. We are convinced that the prosecutor's call for full cooperation, which South Africa fully supports, will ultimately be realized only when the Council stops seeing referrals as an end in themselves. And Your Honor, the reference here is to the summary record of the Security Council. It's the verbatim record of the Security Council, and I would have the reference. It's from SPV.6887 from 13th December 2012. And if I may, Your Honors, the delegate happened to be Mr. Tladi of South Africa.
I'm sure he will find it embarrassing to be quoted. Thank you very much. We will, maybe, Jordan, one more time. Where do you speak at that, please, to your next point? So, Michael might look at Article 2, Paragraph 5 of the Charter. Article 2, Paragraph 5. And the reason why I'm scoping it up front now is to see whether this obligation to give assistance how it relates with an urge. But, Ambassador, please proceed.
Thank you, Your Honor. I'll just deal now with paragraph 2 of the resolution 1593, and then I'll give it to Sir Michael to continue. It should be read in the ordinary meaning of the text, and the ordinary meaning essentially is decides. That's Sudan, and that's the decision language which takes us back to Article 25 of the Charter. As such, this is the fully to cooperate. Now, with regard to what says that recognizing that state parties to the Rome Statute, it's essentially saying your obligations as state parties to the statute are governed by the statute, but it's not placing a direct obligation on the state party through the resolution. And that's understood from the latter part when it says urges all states and concerned regional and other international organizations to cooperate fully, which is a non-binding language.
So would it be then that it is reminding states parties to the Rome Statute that, remember, you are obligated under the Rome Statute and your obligation is governed by that?
I beg to differ, Your Honor.
Correct.
It's just, essentially, it's saying your relationship with the Rome Statute is what it is. I'm not going to be interfering in this.
Thank you very much.
Thank you, sir.
Thank you.
Sir,
Professor Latanzi.
Merci. Pardonnez-moi si je dis que je voudrais apporter un peu d'ordre dans deux confusions qui sont nées pendant cette discussion. Et la première, c'est la question la question que vous avez posée, Monsieur le Président, la différence entre l'obligation de coopérer et l'appel de coopérer. Alors, certainement, il y a une grande différence. Et dans la résolution 1593, on prend en considération dans le paragraphe 2 3 catégories d'États. Un État, c'est l'État impliqué dans la situation. C'est le Soudan, qui n'est pas parti au statut, mais qui, au statut de Rome, mais qui est obligé, par décision du Conseil de sécurité et combiné avec article 13b, à coopérer pleinement. La deuxième catégorie est indiquée par la négative. Ce sont les États membres des Nations Unies et partis du statut, qui sont obligés sur la base du statut de Rome. La troisième catégorie sont les États membres qui ne sont pas partis au statut de Rome. Et pour cette dernière catégorie, le Conseil de sécurité prend, je suis d'accord avec la Jordanie, la décision politique de émaner seulement un appel à coopérer et de ne pas les obliger. Il aurait pu les obliger sur la base du chapitre de pouvoir du chapitre 7. Il a pris cette décision, mais ce n'est pas la première fois, ce ne sera pas la dernière fois qu'il prend la décision pour certains aspects comme l'article 39 lui permet, cas par cas. Donc, mais ici, comme vous avez bien souligné, de quoi on parle? On ne parle pas de la coopération et d'États membres de la Charte des Nations Unies pour lesquels le Conseil de sécurité n'a pas créé l'obligation. On ne parle pas, on parle de la coopération de la Jordanie et du Soudan, naturellement, comme aspect préliminaire. La Jordanie, seulement, la Jordanie, selon ce qui résulte aussi par le paragraphe 2, par la négative, est un des États qui est déjà obligé sur la base du statut. Donc, on n'a pas à s'occuper ici, on peut le faire, c'est une discussion intéressante, académique, de voir ce que cela signifie, et aussi parce que, selon moi, quelques conséquences, cet appel vigoureux, là, quand même. Comme par exemple, je vous ai dit ce matin, je pense qu'il autorise ces États qui ont été appelés à coopérer instamment à ne pas respecter les immunités du chef d'État soudanais. Après, c'est un choix, c'est une faculté, donc les États peuvent répondre à cet appel, ils peuvent décider non, mais quand même, il y aura encore certaines conséquences et qui émanent même, se révèlent même des questions que vous avez posées sous le groupe B. Il y a certaines dispositions générales de la Charte des Nations Unies qui prévoient que les États doivent coopérer avec, en général, et assister l'organisation dans la réalisation de son activité. Donc, quand même, on pourrait même arriver à dire qu'on viole, si on ne répond pas à cet appel, ces dispositions plus générales, et il y en a beaucoup, je ne les cite pas parce qu'elles sont déjà citées dans vos questions. Deuxième aspect sur lequel, selon moi, il y a encore une confusion dans cette discussion, la question Tadic que vous avez évoquée. Oui, là, il y a une distinction très claire entre effet obligatoire et effet coercitif. Effet obligatoire signifie que le Conseil de sécurité adopte des décisions qui sont obligatoires et cette obligation descend de l'acte même. Et je dis cela, je souligne cela parce que maintenant je vais clarifier un autre aspect. Et après, il y a des décisions qui, en plus d'avoir l'effet obligatoire, ont l'effet de limiter la souveraineté des États dans leurs compétences. c'est justement ce que Tadic, le jugement Tadic entendait dire envers les États qui étaient en train de sortir de la ex-Yougoslavie et les États qui sortissaient de la désintégration de la ex-Yougoslavie. Il y avait une limitation de la souveraineté dans la compétence, l'exercice de la compétence pénale de ces États. Ces États ne pouvaient, il y avait la primauté de l'action pénale et de la juridiction pénale du tribunal par rapport à l'exercice par les juridictions internes de ces États. Et cela, c'est un effet en plus de l'effet obligatoire. C'est justement un effet coercitif, limitation de la souveraineté selon le paragraphe 7 de l'article 2 de la Charte des Nations Unies aussi. Alors, dans le cas de... alors, je regrette, je ne suis pas d'accord avec le professeur O'Keefe quand il dit que la question de la coercition, de l'effet coercitif, concerne seulement les sanctions. À part le fait que ce terme sanction n'est pas un terme juridiquement correct, c'est un terme plus politique que juridique par rapport à la réalisation des pouvoirs de l'article 41-42 de la Charte des Nations Unies. Et donc, l'effet coercitif, en vérité, concerne aussi l'effet normatif de créer de nouvelles obligations à la charge des États membres. Donc, d'un côté, il y a l'obligation qui descend de l'acte. Après, il y a l'obligation et la coercition qui descend de la création de nouvelles obligations. Et cela, de nouvelles obligations. Et cela résulte clairement de l'article 41 qui fait une liste non exhaustive des mesures que le Conseil de sécurité peut adopter. Merci.
Thank you very much, Professor. Yes, we will revert now to Jordan, and then after. We'll revert to Jordan, but if it is possible, also the original question posed to the to the Arab League. I know, Mr. Wu, when you spoke earlier, you said you wouldn't deal with that. It's all right if you feel you don't have to respond to it entirely, correct? But it's up to you. But we'll revert to you in any event. You ask for the floor.
Thank you, Mr. President. I'm conscious that the question to the Arab League has led to a very lively debate. I really just wanted to respond to your question, sir, on Article 2, Paragraph 5 of the UN Charter, which, as you know, says that all members shall give the United Nations every assistance in any action it takes in accordance with the Charter, and shall refrain from giving any assistance to any state against which the United Nations is taking preventive or enforcement action. This is quite a general provision that we find in the purposes and principles in Articles 1 and 2 of the Charter. The first point I would make is that we're not here talking about giving assistance to the United Nations. We're here about cooperating with the court. That's the question before us. So I don't think
isn't Chapter 7 isn't the Chapter 7 measure something the United Nations would do, for which member states are required to give assistance?
Well, Mr. President, it may be if the Chapter 7 measure is action by the United Nations. Here, the Chapter 7 measure was action in relation to the International Criminal Court, and it talks about cooperation with the International Criminal Court. But the main point I was going to make about Article 2, Paragraph 5, is that it's quite a general provision, as I said. It's one that is not often referred to, I think, but the key is that when it says shall give every assistance, obviously that means every assistance that it can give in accordance with the law. There's nothing in Article 2, Paragraph 5 that would permit a state to ignore obligations such as the prohibition on the use of force or the requirements of immunities. That was the main point I wanted to make. Just going back to Paragraph 2 of Resolution 1593, it seems to me the position is very simple as regards Jordan's, the extent to which Jordan is covered by the second part of that paragraph, the urges. It does say urges all states to cooperate fully. So it covers all states. But of course Jordan, in addition, is a party to the statute and has an obligation to cooperate fully. So Jordan has an obligation under the statute. It does not have a charter obligation such as would override, under the power of Article 103, its other obligations. Thank you.
Thank you.
Thank you. It's for Jordan. Maybe Jordan can still speak on behalf of Jordan, because Jordan has stated that it has been and it continues to be a stronger supporter of the Rome Statute and the court. So in the given situation of Darfur, how can you envisage the further cooperation with the court? And if you of course, if you are able to give me some pragmatic answer, maybe. Thank you.
Thank you, Your Honor. But if you can specifically, this is a policy question. It's not a legal question. But if there is something specific you would like us to, refer to, we're happy to talk to you about in this regard. But it's, to cooperate with the court on the situation in Darfur. That's it's I cannot. We have to give me something specific that I can answer you on.
Maybe it's because Jordan still is a member of the states parties of Rome Statute, with the specific obligations of cooperation with the court. So now all of these appeals is about a refusal of arrest and surrender of Mr. al-Bashir. Okay, you have your reasons, but then how could we understand the accomplish of your obligations under the Rome Statute to cooperate with the court in this specific case? I mean, if you have the answer,
yes,
okay, you can do. If you don't have, it's okay.
No, that's
it will help us a lot.
Of course.
Thank you.
Thank you, Your Honor. Our appeal is with regard to the specific issue of the visit of President al-Bashir to Jordan on 28th of March 2017. Jordan has been, obviously we want to deal within this context in this regard. Our cooperation is mentioned, it's governed by Article 86, which makes it contingent that cooperation will be in accordance with the provisions of the statute. And as such, we are referring to Part 9 of the statute in this regard. This limits the kind of cooperation in this regard. But we have been a very strong supporter. We were ones who negotiated one of the negotiators of the Rome Statute, and we are among the first 60 countries to have ratified the statute. Our cooperation will continue with the court. Our issue here is the appeal of the decision by PTC2 with regard to referral, finding of violation of the Rome Statute duty of cooperation, as well as referral to the Security Council and the ASP. Thank you, Your Honor.
And your case there is that the essence of that appeal is that, like the fog, if we may call it that one finds in Article 98 what it means for everybody, including Jordan.
Yes. This is a key aspect about it, as was mentioned in our appeals brief. Thank you.
Judge Opaski?
Thank you, Mr. President. I have further two questions to Jordan. The first one is related to the Jordan's answer to the question A. And this question concerns the power of the Security Council to waive, displace, or override the immunity of head of states, specifically whether or not this must be done expressly or can be done by an assess implication. Mr. Woods, how you would explain the requirements that the Security Council of the United Nations, when referring to the situation of Darfur to the ICC prosecutor, would at the same time waive the immunity of the head of state? Don't you think that such a decision could constitute the impermissible suggestion to the prosecutor as to who should be held responsible in that case? I have also the second question to Jordan, if you allow me. It's maybe
after this one.
After this one, okay. Thank you.
Well, Mr. Judge, that's obviously a very good question, and I can certainly understand where you're coming from on it. When we say the lifting of immunity required express language, as I think was also said by one of the friends of the court, that doesn't necessarily mean it has to say we hereby lift the immunity of President al-Bashir of Sudan. It could have been done by saying we hereby lift all immunities that may apply to anyone who may be indicted or whose arrest may be sought by the court. So it could be done in a way that it could have been formulated in a way that was absolutely clear, express, but which did not imply that any particular person was covered. So I hope that's an answer. And if I could take the opportunity to respond to something that was said this morning, I think by the prosecution, it was said, well, the use of force is authorized by general language. It's not express. There's this expression, all necessary means. But I have to say, the expression, all necessary means, is fully understood in the Council. It's known precisely what that implies when that is put into a resolution. There is a long-standing practice of the Council that those words expressly authorize the use of force, and Council members are very careful about the use of those words. So I think that was not a good response to our view that express language is needed. Exactly what the express language is another matter, but I've given the kind of language which could have been used that would not have implied the guilt of any particular individual. Thank you. Okay.
This is one place, it's a word where the matter I posted earlier, marked earlier, comes in. The Kosovo advisory opinion. Here we're talking here in your arises immediately from your response to Judge Hofmeister's question about whether or not express language is needed, and you say it need not be spelled out in that terminology of lifting immunity. But the Kosovo advisory opinion comes in this way. The question it raises in my mind is, here we have in the Kosovo situation where again, you were in that case, if I recall, Resolution 1244, Chapter 7 power, preambular statements recognized, if I recall, the sovereignty of Serbia over Kosovo. But then the resolution authorizes the General Secretary to do something, and Secretary General appoints representative adopts series of regulations. One of those was the constitutional framework, which introduced certain laws and regulations and that sort of thing. Now, the question then became, what effect did both Resolution 1244 and those regulations adopted under it, what effect did they have in international law? And the ICJ said they had a legal effect in international law that effectively amounted to displacement of the sovereignty of Serbia in Kosovo. Did I sum it up well? If so, the question arises, if it is that a regulation adopted by an appointee of the Secretary General would have such an effect as to displace the sovereignty of Serbia in Kosovo, can we by the same token say, well, we don't see the ICC, the Rome Statute, displacing the immunity of Sudan relative to Bashir? You see what I mean? If regulation could do that in Kosovo, why can't the ICC statute do that in Sudan vis-a-vis Jordan?
Well, thank you, Mr. President. And before I answer, I'd like to apologize to the prosecution and Professor Kress. It was Professor Kress who came up with, I think, the notion that all necessary measures was not expressed. But in response to your question, my recollection, and actually Professor Murphy was the one who dealt with Resolution 1244 before the International Court. But my recollection is that the International Court, in its advisory opinion, did not go as far as you have said. In fact, I believe that what it was saying was that it was asked a question, was the Declaration of Independence in accordance with international law?
That was a question, yes.
And in order to decide what was international law, it did indeed, contrary to our submissions, I think, take the position that the regulations of the Secretary General's representatives were international law. And so the question arose, was the Declaration of Independence in conformity with the constitutional framework? And then it decided, as I recall, that it didn't need to answer that question because the Declaration of Independence had not been made by any of the organs of provisional government of Kosovo under the regulation, under the constitutional framework, but had been done by a group of people, the president, ministers, members of the assembly, but not actually of one of the organs of the government of Kosovo. It really wasn't dealing with the displacement of sovereignty, and I don't think it said anything about the displacement of sovereignty. The question was interpreted, well, the question was quite a narrow one. It was certainly interpreted as quite a narrow one that it allowed the court to avoid answering difficult questions about sovereignty.
I may stand corrected, but here is what I recall. I have in my notes here. What led me to that characterization. Maybe I may have overunderstood what was being said. But there's this quote in paragraph 97 of the advisory opinion. Quote, viewed together, Resolution 1244 and UNMIC Regulation 1999/1 therefore had the effect of superseding the legal order in force at that time in the territory of Kosovo and setting up an international territorial administration, unquote. If you supersede the legal order in a territory and set up an international administration for that territory, isn't that displacement of sovereignty to that extent?
Well, you could put it in those terms. It's obviously the displacement of the authority of the Federal Republic of Yugoslavia or Serbia, perhaps temporarily.
Yes,
perhaps not.
It's say temporarily.
It's
interim, yes.
It's precisely what the Security Council did in its resolution, and that was implemented by the constitutional framework. But I don't. That just shows the power of the Security Council. It can do some remarkable things, but I don't think it has any relevance to the question that we're dealing with. The question here is the precise interpretation of the language in the resolution, of paragraph 2 of the resolution, of the second half of paragraph 2 of the resolution, both halves of it. That's a very different situation indeed from what was going on in the Kosovo case. We may be able to learn things about the interpretation of resolutions from the Kosovo case, but I don't think it tells us anything about the meaning of our resolution 1593. Thank you.
Thank you very much.
Mr. President, as Sir Michael has correctly identified me as the one who submitted the argument he criticized, would you grant me a word of reply?
Please proceed.
The point of my argument was about explicitness, a very simple and precise point. Sir Michael Ford Jordan has just a minute ago again indicated how he would feel the resolution should have framed in order to be sufficiently explicit. He would have liked to see the word immunity. Not with respect to President Bashir, he said, and I agree, he said generally, but immunity. My simple point was, in those regulations authorizing the use of force, which, as Sir Michael rightly says, are generally understood as authorizing use of force, the words use of force do not appear. In that sense, they are not explicit. Now, Sir Michael says everybody understands them that way. I entirely agree, but why? For example, because reference is had to the Security Council protocols where those who have voted on those regulations have expressed their understanding. But what is this? This is interpretation. And my simple point was, this is what security practice has always been about. Not the explicit word needs to be used, but under the criteria set out masterfully in Sir Michael Wood's essay, those resolutions have to be interpreted. This is what I wanted to say.
Yes, please.
Thank you very much, Your Honor. Very briefly, in this point, and as a diplomat that spent enough time drafting resolutions in the United Nations, my first comment would be on the language issue. When we draft, yes, we do draft politically rather than legally, but the language we use have a hierarchy. As you mentioned, Your Honor, calls upon or urges might look the same. For us in the United Nations as negotiators, they are not the same. And if the Security Council intended to use urge for other member states to cooperate in the manner of obligation, have ample language we use, whether with the deciding or to demand or request member states to do. So that is one point I just wanted to clear, and that is when it comes to 1593. As far as the point that was just debated between Sir Michael Wood and Mr. Kress-Klaus regarding the decisions and resolutions of Security Council when it comes to the use of force. The language used consistently in all the resolutions of the Security Council when it comes to the use of force, it is standard and it is not by implication. Why I'm saying this? Because the implication and the ramifications of thinking otherwise, especially when a decision is adopted under Chapter 7, is really serious, and it will hamper international peace and security rather than just for the purposes of our debate here. I will just recall quickly Resolution 1441 of 2002 of the Security Council, which actually with it, the reason that we have no mention of the measures that allow the use of force, the invasion of Iraq was illegal. And this is in relation to paragraph 13 of that resolution, which says, recalls in that context that the Council has repeatedly warned Iraq that it will face serious consequences as a result of its continued violations of its obligations. It didn't use the same language addressing the use of force and any other measures to be taken by the Council. So let us be very clear here about the distinction in the language and the ramifications if we go beyond this. This is not only about law and theory, this is about realpolitik, that is about the world out there. Allow me to give the floor to my colleague Dirit Eladi to touch upon one extra element. Thank you.
Very briefly, Mr. Tladley, very briefly.
I shall be very brief. I just wanted to say that in response to the debate that has taken place between, it's when I have it, that in response to the debate that has taken place between Mr. Wood and Mr. Kress, I just would like to make this point. In addition to all the points that Mr. Wood has made, which are correct, there's also a reason why in use of force resolutions, the Council does not use the phrase use of force. The Council is essentially saying you're taking action under a particular article of the UN Charter, and that article is Article 42. That article itself doesn't use force, it uses words like necessary measures, and that's really the place where this phrase comes from, and so why it's not necessary then to have to say use of force. Thank you very much.
So using the language of necessary measures enough to accommodate use of force? Thank you. First of all, Mr. Robinson and then Mr. O'Keefe.
Thank you. I just also wanted to address the alleged rule that the Security Council has to be explicit in order to remove immunities. I think the debate might be a bit off track because we already have UN Security Council practice directly on this point. The UN Security Council has already removed immunities. It did so in resolutions 827 and 944. The language they used to remove immunities was cooperate fully. So if there really is a rule that the Security Council has to be explicit to remove immunities, that rule must have emerged at some point after 1994.
Thank you. Ms. O'Keefe.
Mr. President, as I may, if I may, in a way the debate has gone off a little bit because certain words were put into my mouth The point I was trying to make about explicitness. Now, I was going to go on and make the point that the alternative, if you really wanted to be super explicit about it, would explicitly be to remove immunities. But that was not my point at the time. My point at the time was in a way a bit more generous to the prosecution, because their argument as it is framed is based on the simple proposition that the obligations of cooperation, equivalent to those in the statute, become incumbent upon Sudan by virtue of these words, cooperate fully. My point was that if you're going to displace the fundamental rule of treaty law, which is that obligations in treaties don't bind third parties, and we're not saying, of course, that Sudan becomes a party, but if you're going to displace what is effectively the pacta tertius rule, one of the cardinal rules of the international legal order, one would want that displacement to be a bit more explicit. Now, I said, look, at the very least, words like cooperate fully pursuant to the statute, or pursuant to the obligations, or something like that, but mentioning the statute. The resolution says pursuant to this resolution. So that was my point. In relation to Article 827, no, what removed the immunities was the statute. What removed the immunities was the statute of the International Criminal Tribunal for the former Yugoslavia. In paragraph 2, the Council decided to create a tribunal as provided for in the statute, which it then annexed, okay? So the focus is not paragraph 4, the obligation of cooperation. The focus is paragraph 2, the establishment of a tribunal which did not allow the invocation of immunity. This brings us finally back to Article 25, because the Article 25 is not just to carry out the decisions of the Council, it's to agree with them. So the reason states had to swallow the abrogation of immunity in relation to the ICTY was the obligation to agree with the decision taken by the Council in paragraph 2 to establish a tribunal with the powers in the statute annexed to it. It was not the obligation to cooperate fully in paragraph 4. So what removed it was the statute, not paragraph 4, if I can make that distinction.
Try speaking very as close as possible to the
microphone.
sorry.
Like you, I become a bit excited. Yes, yeah.
You don't have to lean onto it.
Yeah,
Just
sure. That was really the extent of the point I'm trying to make, is that what took away immunities in relation to the ICTY were not the words cooperate fully. Okay, so in a sense, it's a lovely argument. I just find it a bit of a sleight of hand, because it's paragraph 2.
Can you explain? I'm trying to understand the difference between your position and Mr. Robinson's position.
Yeah, right.
He's arguing that immunity is removed because the Security Council referred to the case pursuant to a document that removed immunity. And you are saying in the ICTY and ICTR scenario, immunity was removed because there was a resolution that annexed a statute that removed immunity. Help me break it down.
My focus is not the words cooperate fully. They weren't what took away immunity, as it were. What took away immunity was the decision in paragraph 2 to establish the tribunal which didn't allow immunities, okay? That's my distinction to that extent. Now, in cooperating fully under the statute, okay, but the statute also provides for Article 98(1), etc., etc. So in a sense, it's a bit of a circular argument. So that was the simple point I was trying to make. In terms of apologies, I'd like to apologize too if I was a bit emphatic in my previous point. I am accused of having a childlike exuberance, which is probably another way of saying I'm immature, but I didn't mean any disrespect to Ms. Brady in my former submission.
We will now take a question from Judge Boza. Okay. Yes, please, Professor Latanzi.
Sur une chose, je me trouve d'accord avec le professeur, que ce n'est pas de dire coopérer pleinement et d'enlever l'immunité. Mais que du fait que dans les statuts de la ex-Yougoslavie, il y avait cette règle qui est la même, à peu près, avec des mots quelque peu différents, qui est la même, qui est dans le statut de la Cour pénale internationale, ça dépend, et qu'il y a cette différence. Mais la différence, c'est que dans le premier cas, c'est le Conseil même qui a créé le statut, adopté le statut. Et donc, il a mis dans ce statut l'exception à l'immunité. Dans l'autre cas, il utilise un instrument qui est déjà là, qui contient cette même règle. Il l'utilise et veut l'utiliser aussi par rapport à l'article 13b, selon les règles de ce statut. Donc, par renvoi à cette règle, il suspend aussi du point de vue substantiel, la règle est contenue dans le statut de Rome. Du point de vue formel, pour que cette règle ait l'effet envers le Soudan, c'est l'application conjointe de la décision du Conseil de sécurité et du statut, donc de la règle 27. Mais seulement une précisation. Alors, on a dit, mais quand même, pourquoi décide dans le paragraphe 2 de la résolution? Pourquoi? C'est la Jordanie qui nous a dit. Pourquoi il a dit si c'est la décision du Conseil de sécurité? Doit. Et le professeur O'Keefe nous dit de son côté que ce fait signifie que le Conseil de sécurité n'a pas enlevé. Alors, je ne suis pas d'accord, parce que le paragraphe 1 attribue la juridiction envers la situation à la Cour pénale internationale, attribue la juridiction de cognition et d'exécution selon les règles du statut. Donc, selon aussi l'article 27 et le terme juridiction utilisé dans l'article 27. Après, le paragraphe 2 dit que le Soudan doit coopérer pleinement. Décide. Pourquoi décide? Mais pourquoi, quand même, toujours par le fait que l'effet obligatoire et limitatif de la compétence du Soudan, c'est quand même la combination, la conjonction de la décision du Conseil de sécurité et de l'article et du statut, l'article 13b. Et donc, c'est pourquoi il doit dire décide et il ne peut pas dire doit seulement sur la base du statut. Parce que pour cette combination que l'article 13b renvoie au pouvoir du Conseil de sécurité, le Conseil de sécurité utilise sur la base de cette disposition, on doit lire ces dispositions en conjonction. On ne peut pas les lire séparées. Le paragraphe 2 de la décision du Conseil de sécurité, on ne peut pas la lire sans faire référence au statut.
Thank you very much, Professor. And Mr. Newton.
Mr. President, I rise just a bit reluctantly, conscious of the hour, but I feel like in some ways we're talking around issues, and I want to just call us back to the core. We began the day with the word pragmatic and the idea of pragmatism. The real critical issue here is what was the intent of the Security Council in Resolution 1593? And as I said earlier this morning, a full digesting, if you follow from the beginning of the arrest warrants till today, you'll see a very clear distinction in the intent and in the statements of the Security Council between Sudan and the parties in Darfur and the obligations incumbent on other states. It's extremely clear. I simply want to read very quickly, and then I will sit down, the statement from the very last, the 27th prosecutor's report. This is the United Kingdom delegate. Now notice what he says very carefully. In adopting Resolution 1593, this is, by the way, for the record, is the 20th of June of this year, several months ago. In adopting Resolution 1593, the Council committed to supporting the Office of the Prosecutor in its efforts to investigate the situation in Darfur. Of course that's true. We must therefore act upon the prosecutor's request to the Council to take effective measures to enable the court to carry out its mandate in Darfur. That references what I said this morning, that there were these consistent and rising pleas, that what you've done is insufficient. Please do more. Please help us. Here's the key. In particular, by asserting the need for all states to cooperate with the office's investigation. What does that mean? With specific reference to fugitives. The United Kingdom continues to be frustrated that fugitives from the court, including President al-Bashir, Mr. Haroun, and Mr. Hussein, are still traveling to certain countries unhindered. For its part, the United Kingdom will continue to raise its concerns with the relevant governments, including through the European Union. And here's the key language. We renew our call on all states parties to cooperate with the International Criminal Court and abide by its obligations under the Rome Statute. If, in fact, as late as June of this year, it was so clear in the eyes of the Security Council that both of those paragraphs, both of those legal duties were fully synonymous, that language would not be necessary. And you see it over and over and over again. A clear distinction between the duties incumbent, and I completely agree with the last comment, vis-a-vis Darfur, the situation in Darfur, and the parties to that conflict. That's extremely clear. But vis-a-vis other states' parties, the consistent call is comply with their obligations in conformity with their obligations under the relevant treaty, which includes Article 98. And therefore, in my reading of all these records, no Security Council member has stood up and said Article 98 is irrelevant, and therefore, I'll conclude by exactly what the United Kingdom delegate recommended. We renew our call on all states parties to cooperate with the International Court and abide by its obligations under the Rome Statute. We also urge them to consult with the court if they feel they're unable to cooperate with it for any reason. Meaning, consult with the court, cooperate with the court, but you do not have, under Resolution 1593, an overarching obligation to do every single thing they ask you to do. If you have a dispute with that or a need for further clarification, or you find yourself in a legal quandary, consult with the court, which, as my understanding, is exactly what happened on the facts of this case.
Thank you very much. And then we will give the floor to the African Union, and that will take us to the end of sitting for the day. Yes, Mr. Jallo, you asked for the floor.
Thank you, Your Honors. I did. Your Honors, I am also mindful of the time, so I'll try to be very brief. My point is to do something very similar to what Mr. Newton has done, which is to do a bit of a reminder. And the reminder is with respect to the debate and the discussion we're having a little bit earlier, but that actually is still central to the particular matter before us in the sense of the circles we're doing around how do you interpret Security Council resolutions. And I think Mr. Wood made an important point yesterday where he suggested that we have to remember the Security Council is a political animal. And Your Honors underscored that point today as well. And I think my statement earlier by Mr. Tulari on behalf of South Africa also underscored that point. But there's a second point that's a legal point that is very important in this particular context. It relates to a question about Resolution 1244 in the context of the Kosovo case. And there's a nice and interesting paragraph where I think the ICJ made 3 points that we ought to remember, and this is in paragraph 94. And if you bear with me very briefly, Your Honors, I'll just pull out the key points. Essentially, the court was dealing with how then do we interpret this element that you raised earlier. It said we have to look at the treaty rules, so Articles 31 and 32 of the VCLT, and it says they may provide guidance. Differences between Security Council resolutions and treaties mean that the interpretation of Security Council resolutions also require that other factors be taken into account. And those 3 factors are very important for the interpretation in this chamber of 1593. 1, Security Council resolutions are issued by a single collective body and are drafted through a very different process than that used for the conclusion of a treaty. 2, Security Council resolutions are the product of a voting process as provided for in Article 27 of the Charter, and the final text of such resolutions represent the view of the Security Council as a body. 3, moreover, Security Council resolutions can be binding on all member states, and I believe this is the point that you are emphasizing, Madam Legal Counsel, bringing your rich experience in the General Assembly to the discussion in terms of this language. And it says, irrespective of whether they played any part in their formulation. And I will conclude with this point. This is again from the ICJ, paragraph 94. The interpretation of Security Council resolutions may require the court to analyze statements by representatives of members of the Security Council made at the time of their adoption, other resolutions of the Security Council on the same issue, as well as the subsequent practice of relevant UN organs and of states affected by those given resolutions. My submission, Your Honors, is that within the context of 1593 and this whole language that we are debating, urging, deciding, calling upon what are the effects of those, well, in the end, they cannot be taken out of context. They've got to be taken in context, but then you also have to look at the reactions of states. And I think from the perspective of the African Union, there's been a clear position on the issue of immunity, but also a clear position on the claim that non-parties would have an obligation in the context of a decision that basically binds only the referred state. And of course, I'm talking about Sudan. Thank you, Your Honors. I know it's late, so I'm going to end there.
And thank you very much. We will leave it there for the day, and we reconvene tomorrow at 9:30. 9:30, not 9 o'clock. 9:30. So we will.
All rise.
Yes, we'll continue.